And to set the stage, so you'll understand how this arose, is counsel for Mr. Malmo-Levine and his co-accused said to Mr. Justice Curtis that they wished to challenge the marijuana laws under the Charter and that they had evidence that they wished to call to support the challenge. Mr. Justice Curtis said, well, just a minute. Before you call that evidence, tell me where at the end of the day you think it is going to get you. If falling back into the vernacular, give me your best shot. What counsel for Malmo-Levine and the co-accused then did, because Mr. Conroy had preceded them before in another court in the Caine matter, is they basically took Mr. Conroy's entire submission and statement of facts based on the evidence that he had called before Judge Howard, which was essentially the same evidence Mr. Malmo-Levine wished to call, and placed it in front of Mr. Justice Curtis and said, here's a list of the facts that we say we can establish by calling this evidence. Mr. Justice Curtis said, I accept that. Assuming you can prove those facts, you do not get a remedy. In my respectful submission, that's an appropriate thing for a trial judge to do. Because, and to be quite frank, I submit there's somewhat of an inconsistency in the judgment of Mr. Justice Braidwood in the Court of Appeal on this point, because what he says is, in a very short paragraph, that was a wrong thing to do. He should have been allowed to call the evidence, but since we've heard the appeal in Caine and it was the same evidence, the result would have been the same, and therefore no substantial wrong or miscarriage of justice. I say that in Charter and other litigation, it's entirely appropriate for a trial judge to say to any party, okay, what is it that what facts do you rely on? Before I get into a hearing that might take 3 weeks, 4 weeks, or a month of evidence, at the end of the day, what do you say the facts are that you rely on? And if counsel or an in-person accused articulates those facts, and those facts in the mind of the trial judge don't establish whatever it is has to be established to obtain the remedy being sought, then it can be dismissed. The calling of the evidence is a waste of the court's time.
May not rest at the trial level. I mean, here, it would be one thing if the trial judge said, you can put Mr. Conroy's submission on the record and deal with that for purposes of this case as agreed fact, and telling you that on the basis of those agreed facts, you don't have a case. Then it goes up and there is some record for the Court of Appeal to deal with, as opposed to the judge saying, well, I don't think that makes the case, so I'm not going to hear it, so there's no record, so that if you go further, you've got nothing to rely on.
There may be cases where a trial judge is found to have acted precipitously, and a new trial will have to be ordered on that basis.
But in this case, was the submission that you speak of, that Mr. Conroy made, put on the record and accepted as being the factual basis of the challenge, but then rejected as a matter of law?
Yes.
Simply kept out altogether.
Oh, no. And that's why when I was looking at this the other night, I realized that I was doing my argument a disservice at line 40 on page 51 when I used the heading failure to hold a voir dire. It should more accurately read failure to hold an evidentiary hearing, because there was a voir dire in the sense that counsel for Mr. Malmo-Levine and the co-accused were put forward the facts that they said they can prove, and then they argued whether those facts entitled them to a remedy. So it wasn't a matter of the trial judge saying, I simply won't hear you on this. It's, I don't need to hear evidence right now because I want to look at this in a preliminary way. And in a way, if I could ask the Court, because I'm going to move from this, to make a note of one recent decision by the Court of Appeal for Ontario, which lends some support for this proposition. It's a case called La Rosa, L-A-R-O-S-A, and I did notify my learned friends and others some time ago that I was going to cite this, or might refer to it. 2002, 166 Canadian criminal cases, third series at page 444. Mr. Justice Doherty, and I asked the Court to consider paragraphs 76 and 77 of the judgment. This was an extradition matter where there was an application made in the Court of Appeal for disclosure of material that hadn't previously been disclosed, and an application to adduce fresh evidence. And one of the things that Mr. Justice Doherty said in refusing it is, given that the allegations that there was no point in making the order, because given the allegations that were being made, those wouldn't support the remedy being sought. So it's just another example of a court acting as a gatekeeper. So I say that as a matter of law, the Court of Appeal for British Columbia in this case was wrong to find that the trial judge had erred in adopting the procedure that he adopted. The Court of Appeal was right in the result, because the calling of that evidence would not have made a difference, but the Court of Appeal ought not to have said that trial judges placed in this position are required to hear evidence and cannot look for more efficient and expeditious ways of dealing with the matter, bearing in mind, as they always must, the need to protect the rights of the accused and the interests of the parties generally. But I say the exercise of the gatekeeper function by Mr. Justice Curtis, as the record ultimately in this matter bears out, did not in any way impair the right of Mr. Malmo-Levine to a fair trial on this particular issue. I've already touched on, to some extent, the division of powers point. Hauser is out there. Hauser may have been criticized by academics, but it is nonetheless a decision of this court that has stood for some time. Whatever the critics of Hauser may say about the majority's reliance on peace, order, and good government, those critics, save for those counsel before you today, agree that it's valid federal legislation. If it's not POG, it's criminal law. And when you look at what was happening in Hauser, everyone agreed that it was valid criminal law. Even the dissent by Mr. Justice Dixon, as he then was, agreed. And then we moved to a case that those opposite me rely on, Schneider, the comments of Chief Justice Laskin in the BC heroin treatment case, where he says, speaking for himself, had I been on Hauser, I wouldn't have agreed it's POG, but I would have upheld it under criminal law and trade and commerce. So there's ample support in this court for the proposition that the Narcotic Control Act is valid federal legislation. And in my respectful submission, you look at, on a division of powers basis, and Hauser was a marijuana case, but beyond that I say that from a division of powers perspective, it's not a matter of once having decided that this is valid federal legislation, of going through the schedule and saying, and reassessing each of the drugs. It's either valid legislation or it's not. This court has held it valid. And in my submission, there's no reason why this court should depart from Hauser, other than perhaps to say that upon further reflection, the criminal law power is also a power that supports the Narcotic Control Act, and certainly would support its more recent successor, the Controlled Drugs and Substances Act. I've made the argument in the factum. We say it is it's valid federal legislation. I also ask the court to consider the submission that we make starting in paragraph 153 and paragraph 57 concerning the margarine reference. Because what the other side seems to be saying is that you can have a shift based on scientific or other evidence. You can shift from one head of federal power to a head of provincial power, or perhaps vice versa. In my submission, that's not what happened in the margarine reference. My submission on the margarine reference is that at the time the legislation was, when the legislation which was subject to challenge, ultimately subject to challenge, was reenacted by Parliament in a different statute, at that time there was no criminal law purpose. And it was for that reason that the legislation was struck down, because when Parliament acted to reenact it, it did so solely to protect the dairy industry, and as this court is well aware, that is not a valid criminal law purpose. But unless you're dealing with law that is supportable, federal law that is supportable by the emergency POG power. In other words, there has to be an emergency, and when the emergency lapses, the support for the legislation lapses. Unless you're into that category, there's not a shifting. At one time it may be criminal law, at another time it may be property and civil rights. It doesn't go back and forth, because if you accept the argument that's being made with respect to the margarine reference, you could technically have a situation where, because of a shift in attitude and perhaps other changes in society, we would now take the Aeronautics Act or nuclear energy and say, well, at one time they were federal, now they're provincial. Okay. The only time legislation, which is validly enacted at the time it is enacted, can, by subsequent events, in my respectful submission, become self-invalidating, is under the emergency power of POG, and this isn't one of those submissions. The last thing I want to touch on before I sit down is, of course, the order that the respondent seeks with respect to the answers to the constitutional questions and the dismissal of these appeals is set out on pages 65 and 66 of the factum. I do want to just mention one thing about the suggestion, and it's made in Mr. Arve's factum for the British Columbia Civil Liberties Association in paragraph 80 on page 20, and I'm not sure if it's in the Canadian Civil Liberties Association factum, but my learned friend Mr. Loken did refer to this. The possibility about sending these cases back for further trial, back to the trial judges, because Mr. Arve specifically says that. Strike down possession. It's in Mr. Arve's factum. It's in Mr. Arve's factum. But it's there, and I just. Well, no, the point I simply want to make is these are indictable matters, and this court, in cases such as Warsing and Thomas, it says if it goes back for a new trial, you're back to square one. There's no power in this court to take a case, any of these cases, and say the appeals are allowed, and the result is we refer it back to the same trial judge to continue the trial, perhaps in Mr. Malmo-Levine's case, to continue the trial now to decide whether the trafficking or possession for the purpose of trafficking provisions are unconstitutional. If the appeals are allowed, and the effect of that is that there has to be a new trial, you're back at square one. And that's what this court has said, and I just wanted to raise that. I didn't want to leave it hanging.